Go to the Full English Show. We are live every evening, Monday through Friday, on Rumble. The King on application is Staple versus the Solicitor General. The number's up there. Skeleton of argument, judicial review. You are very restricted because this is actually an appeal of being rejected for judicial review. It goes into a more senior judge who looks at it. The judge who looked at it, I've shown you him and his wife. You couldn't get more diverse than them. They're a pair of fucking communists. So I'm going to read the application out to you. There's a few pages of it. Crucial to this application is the separation of powers and the misinstruction via training of the learned judge with reference to the powers of the judiciary. And don't forget, there's already a grounds one gone in. So this is the skeleton argument. It's a separate argument where you're expanding on the points. With reference to the powers of the judiciary to quash repugnant or contrary to domestic constitutional law or United Nations international human rights laws, not just ratified, but incorporated, this is really important, into English domestic law. Now, normally, the argument in court is in reverse of this. And that is that they will say, just because we ratified something, it doesn't mean it's law because we haven't incorporated it into English law. Whereas the Criminal Justice Act 1988, Section 134, they have incorporated it into English law. So it's an incorporeal right. This wrongful assumption has been applied through the misinstruction that Parliament is sovereign. The constitutional separation of power is fundamentally important, as Her Majesty stated to both Houses of Parliament on July 20th, 1988, not just a speech, but a declaration, an agreeable proclamation in celebration of the English Bill of Rights of 1688. Various scholars, including Wade, Dicey and judges, both retired and serving, concur with the view, including in more modern times, that Parliament is a primary legislator which has boundaries set by the Constitution of England, a country since the year 927, 1096 years young. If it strays from them boundaries in error or otherwise, either the monarch or the judiciary can void such error in law that concern the liberty and protections of the subject. So whether or not you like being called a subject, the Constitution refers to you as a subject, and so does Lord John Somers, who is the framer of the English Bill of Rights, who was the framer of the Acts of Settlement of 1701, Chapter 4, that says that every Englishman, their birthright are the laws of England. So remember where this comes from, and they was protecting you for the future. If Granville Sharp's views, and you should all know who Granville Sharp is, views, opinions and cases on slavery were brought before the system of law today, 2023, as a layman, he would have struggled to get past the civil procedure rules, and if he did get past them, B, his case would have been certified totally without merit, as the majority of the upper middle class, including judges, lawyers, as in the case of the slave Jonathan Strong, his master who beat him to within an inch of his life was a lawyer, David Lyle. Solicitors and even clergy were masters, owners of slaves. Sir William Blackstone, Sir Philip Yorke, Attorney General, Charles Talbot, Solicitor General of the era, all disagreed with Granville Sharp. Even the judge in the Somerset case, again, Somerset versus Stewart, 1762, Lord Mansfield, gave previous opinions positive to the legality of slavery until the case was argued and evidence presented. Remember that Talbot and Yorke in 1729, they come out with this case, and it was to go against what Sir John Holt had said in the case of 1698, I think it was, and 1704. And I'm sure it was the Lewis case. And it was involving a case that was brought for a slave that was brought from Russia. And basically he said, when a slave sets foot on English soil, they are free. So again, in paragraph 3, in cases of importance to English jurisprudence, such as slavery, the lay individual Granville Sharp in effect brought the heinous crime to a halt via the common law of England. In the cases of slavery, the Yorke-Talbot opinion, 1729, and again, there they are named, calls the slavery, murder and torture of slaves, and you all now understand about HM, Her Majesty's ship, Yong, calls the slavery and murder and torture of slaves to continue, and their opinions were in direct contrast to Sir John Holt's judgment on slavery. The current case is not unique in law, but parallel in consequence and similar in legal circumstance. Why is that? Torture, as slavery, is internationally recognised as a crime against humanity. But when the state is so close to the indulgence in this crime, it finds itself biased in its rulings, which is why the usurpation of the jury function by the Attorney General and Solicitor General is fundamentally wrong and should be examined by judicial review. The English Bill of Rights of 1688 was designed as legal certainty, as Granville Sharp used these rights to free the slaves. For example, a key law used by Sharp to free the slaves used the words of the preamble of the English Bill of Rights, 1688, securing the liberty of the subject. Although he used Habeas Corpus Act 1679, they share a legal maxim, and one protects the other until the legal protection was unlawfully repealed, therefore not auxiliary to this case. I use these rights to assert my right of free access to these incorporeal rights. The ultimate social justice is the English common law, based upon the ultimate distributed system of governance, the ultimate antithesis to misconceived legal political theory of communism or indeed fascism, and authoritative tribunals based on administrative law, the opposite to the common law. That ultimate system of the jury and jury nullification of bad law, which can work for the proposed defendants. When by stealth or fraud, the separation of powers failed, the last saviour is the jury. When all politics, judiciary and the crown has failed, the subject of the majesty of England, then the last bastion of humanity should prevail, the jury. The authorities relied upon are the ancient laws, statutes, customs and precedents of the common law that our ancestors fought to preserve for the liberty of the people. These include, but are not limited to, Halsbury's Laws of England, the Law and Custom of the Constitution, Volume 1 and Volume 2, Lord Anson, Institutes of the Laws of England, Sir Edward Coke, select statute cases and documents to illustrate English constitutional history, C.G. Robertson, Memorandum of Law and Constitutional History, Alexander Sharp. Who wrote that book? Granville Sharp's brother. When a police constable, now referred to as an officer of the law or a law officer, states to a member of the public who is protesting, petitioning and asserting their rights by authority of the English Bill of Rights, the member of the public declares peacefully to the law officer the English Bill of Rights is in full force. And the law officer, clad in full riot gear with button drawn and protective shield as a weapon, enforces the government policy, not law, declares in response, not today it is not. Video evidence can be supplied. No matter who the law officer is, this response is, according to law, contempt of sovereign and contempt of statute, an offence at the common law according to the Halsbury Laws of England. Again, this contempt extends to all law officers. Granville Sharp cited Habeas Corpus Act of 1679, an act for the better securing of the liberty of the subject. This is one of our manifesto constitutional documents that's in there. If you think about the European arrest warrant, which is illegal technically under English law, this protects you. An act for better securing the liberty of the subject and for prevention of imprisonment beyond the seas. Now, the key element is the Habeas Corpus, it says and. So the key thing here is the word better securing the liberty of the subject. You then look at the second element, and that's to do with the overseas part. But the first is the liberty of the subject. I, Charles Staple, as a layperson, cite above the English Bill of Rights of 1688 as originally enacted by a convention, Parliament. What is the long title and preamble of this bill? Appendix A. So you go to Appendix A in the document, and do you remember the appendix we've got? I'll bring it up if you want. The reason I'm going over this is so you understand what's going into the High Court. Crucially, the law was set out, albeit by a layperson in plain English, in full representation to both the Attorney General and Solicitor General and the judge at first instance. The misconception, ill-conceived or misconceived notion that Parliament has unfettered powers is not supported by the Constitution of England, nor indeed that the AG, SG opinions are final and not reviewable. Their opinions of 1729 were in fact struck out by Lord Mansfield in the Somerset versus Stewart case, 1762. Why is this important? Because they're comparable, because they're both international crimes under international common law. And it's really important that people understand that. In closing and conclusion, A, this is not a case about legal fiat or legal fiction. RV Solicitor General ex parte Taylor, 1996, COD 61. But as the ruling in Gourier versus Union of Post Office Workers, 1977, UK House of Lords, 526, 1977, and this is the one Lord Denning was involved with, there's a conflict. This is a private prosecution for torture, and the facts are for the jury as the final arbitrator of justice, without positive bias of the state towards a crown servant. A police constable swears an oath to the crown or to the sovereign, and Parliament is declaring itself as sovereign, so they are declaring their loyalty to Parliament, no one else. That's wrong. Unlike American police officers who swear an oath to the Constitution. That's the important element here. And bearing in mind, the American system is the old English system. In this matter, the subject pertains to England involving private rights, public rights and special damage. As elucidated in the Gourier case, the ruling in Gourier was adverse to the petitioner because they lacked a direct private right, public right or special damage. In contrast, in other words, Gourier was asking for the fiat or legal fiction of the Attorney General to bring a case in the public interest. So in other words, the Attorney General is lending his title to him, his legal fiction or his fiat, for him to do it. But they said, no, he don't have to do that because Gourier wasn't affected by the Royal Mail strike. This was all to do with the Royal Mail and the communists in the Royal Mail were blocking all mail coming in from South Africa. But because Gourier wasn't directly affected by it, in other words, he didn't know anyone in South Africa, he wasn't waiting for a parcel or a letter, it wasn't affecting him at all. But what they said in that case, if he had been directly affected, this is the position. And that's why we're doing it, because we're not asking for a legal fiat. We're not asking for a legal fiction of the Attorney General. This is a direct private prosecution. And the Lords in that case said, this is a remedy. If this happens, you privately prosecute. And again, there's another case where the UK Supreme Court has already now knocked it on the head, so you can't privately prosecute anymore. CPS can step in and shut the case down. So all of this is involved in this case because it's taking one of the core legal rights available to you, right, to protect yourself. The ruling in the Gould case was adverse to the petitioner because they lacked a direct private right, he lacked a private right, public right or special damage. In contrast, the current case aligns with my own position, that of Charles Staples, as it directly affects me. Consequently, I possess legal standing and the Gourier ruling takes precedent over Taylor, in line with the constitutional and corporal rights inherent in the English Constitution. These arguments are detailed and substantiated by both international and domestic law as presented in the comprehensive skeleton argument for the appealed case, reference AC 2023, London, blah, 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 right? It is a case of incorporeal right, both via international common law, treaty, and English convention right. Remember, the English Bill of Rights, it came from a convention parliament. It didn't come from an ordinary parliament. So you extrapolate what Sir John Laws said, and this is where you get the information from. It is a case of inculpable right. So again, F. Furthermore, it is important to note that the Attorney General and Solicitor General did not have access to any statement from the potential defendants in a private prosecution, police officers, who may face charges of torture, as mandated by the law under Criminal Justice Act 1988, Section 134, which explicitly requires them to, and it says must, establish the legality of their actions. Given that the least intrusive measure available to them was to issue a fixed penalty notice, it becomes imperative for them to provide a justification for resorting to the use of force to ensure government policy rather than the law. The degree of force employed reached the level classified as severe pain, as indicated by the victim's statement, and the enduring suffering resulting from the prolonged malicious prosecution. In light of these circumstances, it becomes evident that the decision taken by the Attorney General and Solicitor General was both unlawful and irrational. And then I finish on this. William Pitt, 1st Earl of Chatham, 1708 to 1778. Instead of the arbitrary power of the king, we must submit to the arbitrary power of the House of Commons. If this be true, what benefit do we derive from the exchange? Tyranny, my lords, is detestable in every shape. None so formidable as where it is assumed and exercised by a number of tyrants. But, my lords, this is not the fact. This is not the Constitution. We have a law of Parliament, we have a statute book, and we have the Bill of Rights. That is the submissions. So again, that has been submitted to the Court of Appeal. Now, remember, everyone, and especially the wording of this, we're expecting a knockback. And this system is so corrupt to the core, they won't allow this to go further. So we then need to appeal it again, whether it would be to a more senior judge, whether it's to the Supreme Court. But each knockback and the relevant information produced for that, and there's a lot of work that goes into it, opens the door wider and wider and wider to universal jurisdiction. So the objective is to bring this under universal jurisdiction where the British courts have signed up to and ratified the United Nations Convention Against Torture. And because of that, they have ticked an agreement box internationally, for example, with Russia, for example, for any of the federal courts in the United States of America, that their courts can hear this on the behalf of a subject of the realm of England, and you are in effect suing the King of England in the United States of America. And their jury is going to sit there and listen to a case, and if you speak to any American, they'll tell you. They don't like centrally controlled federal police. When you explain to them that's what the Crown means, centrally controlled Crown police are the equivalent to your feds, and that the police officers are not like your sheriffs. They do not swear an oath to the Constitution. They swear an oath to the sovereign or to that federal government, not to you and not your rights. That is then opened up. There's 3 separate laws that allows us in the United States of America to bring the case. It's already happened in the past. So Vince Cable, the Nigerians tried to sue in British courts. And the British courts shut it down and shut it down and shut it down because 9 of their people were murdered and tortured on behest of Royal Dutch Shell. And Sir Vince Cable was on the board of directors at the time. So they tried to sue Royal Dutch Shell and Sir Vince Cable. And what did they do? They took it under universal jurisdiction to a federal court in the US, went up the chain, got to the point, and they said, we'll settle. The point is, there is no permissions being asked. In the United States of America, they stopped asking the Crown's permission in 1776. So remember, every operation is opening a door to universal jurisdiction. And let me tell you this, the jury award in the state that we're bringing it. One, it will be conservative. And secondly, the award from the jury will be unlimited. Whatever that jury says as award of damages, that's what the Crown, King Charles III, has to pay, because he is the head of state. He and government and the judiciary caused that case to be brought under universal jurisdiction. Remember that.